Hi, thanks for joining me in this video. This is Norlin Oligosarma, your licensed immigration consultant. This video is about how to lift a ban. For those of you who've received the ban, it's probably the most devastating letter you've ever received in your lifetime. A ban is exactly that, means you are banned from entering Canada for X amount of years. Could be anywhere between 2 to 5 years. Most bans that are issued are due to misrepresentation. You have misinformed the immigration officer about something. And what's very important is that the misrepresentation can be direct or indirect. Direct means you knew about it, you had knowledge about it, and you still presented that misinformation to the officer. Well, that's a big no-no, and there are also many clients that do misrepresentation unknowingly indirect. They didn't know. They had to reveal this information and so forth. When they received the refusal and on top that get a ban, they're like, there must be a solution. Knowingly lied, it's the same thing. There is no excuse to that misrepresentation. That includes to the extent that you had a third party present those documents and that misrepresentation on your behalf. Unfortunately, again, if you've had a friend or family member who helped you and they accidentally misrepresented an information on the form, the responsibility is on you. The officer will not accept, "Oh, I didn't do it. My friend helped me and he submitted the application." Again, the officer will come back and say, direct or indirect, misrepresentation is misrepresentation. Nonetheless, and so, misrepresentation usually gets a heavy ban of 5 years. And to overcome that ban is close to impossible. Usually, when you get a ban or prior to getting the ban, you get something called the Procedural Fairness Letter or PFL. A PFL, when you receive this, immediately seek legal representation. I beg of you, do not attempt to handle a procedural fairness letter on your own. This is the point, this is the time where you could potentially salvage that potential ban. If you fail at the end of the procedural fairness letter, chances are you are never going to be able to lift that ban, which means it's going to carry on for X amount of years depending on what the officer issues. And lots of people think that what if I apply for a temporary resident permit? Because a TRP overcomes an inadmissibility, and the answer is no. You cannot overcome a ban with a TRP. You cannot overcome a ban with a criminal rehabilitation. A ban is a firm stop that. This is the last application that we will consider to allow you enter Canada. The country, there isn't a single H and C argument that you can make where the officer would consider if you had your chance at the procedural fairness point. To make those arguments now, there is one silver hope where I've seen and have been lifted. And that truly was in a situation where a client had hired a representative, and that representative, without their knowledge, without confirming with the applicant, submitted documentation on their behalf. Even still, the officer can deny to lift the ban at that point. But on very rare circumstances, the officer may consider it could be your documentation. It is your file that's being uploaded on your GCK account or the representative's GCK account. And prior to your clicking submit, it asks for a final validation and a final signature. And only the client should be clicking that signature. So, when you click that, it gets uploaded as you, the applicant. So, if you're having someone represent you, make sure that you review and approve everything from the forms to the documentation that they're going to upload to the legal submission letter that they're going to submit. If you do not give your approval every step of the way. Make sure to take back the login information and submit the application yourself, because in the end, it's going to be on you. So, I'm talking about when you ask for a friend or unlicensed immigration consultants, because for sure they're gonna have to create your own GCK account. However, if you're hiring an immigration lawyer or immigration consultant, that we will be using our own GCK account. So, lifting a ban is close to impossible if and when you get the procedural fairness letter. Do give me a call, because it is at that point that we may be able to do something. Even if it's a refusal, I tell you, my clients, it is better to get a refusal than getting a refusal with the ban at the stage. All I care about is for that client not to get that ban. If it's refused, you can always resubmit. But if it's refused with a ban, you have to wait until the time has elapsed. Once the time has elapsed, let's say you've been patient for 5 years, then you can proceed as if nothing really happened. Just you make sure in your future application, you mention that at one point you did get rejected and you did get a ban. It shouldn't affect, I repeat, it shouldn't affect your prospective applications once the ban is lifted. You move on. In that ban, you are banned to submit any application that includes temporary and permanent. Some clients think that they're eligible to submit a spousal sponsorship application or a different type of express entry or something like this. And the answer is no. The ban is stopped. We do not want to see any application from this date until the 5 years have finished. So, if you have questions about this, or if you have received the procedural fairness letter, please give me a call today. Thank you so much, and until next time, all the best, everyone.